Good afternoon, everyone, and welcome back to our weekly webinar series. And festival greetings to everyone. Happy Dhanteras for today and happy Diwali. We are doing the part 2 of related party related compliances and disclosures and activities in IBC and the various processes to understand related, differentiate related parties and so on. So over to Anil, sir.
Thank you, Ankit, and my greetings to all the participants. As first of all, as Ankit said, I would also give you the good wishes for Dhanteras and Happy Diwali to all of you, and wishing you the best of the festival season of India. This concept of related parties, as we tried to analyze, and we could see there are three different issues as far as the related parties during IBC is concerned. Now, the first issue is the constitution of committee of creditors, and the related parties are not supposed to be a part of the committee of creditors. And we discussed why the government thinks so, why the judiciary thinks so, and they are very particular about it. And what the judicial pronouncements are saying, that this is a very, very wide definition and for the related parties. And it is even said that even if some changes have been made later on, but if the transaction time, when the transaction happened, at that time, if the creditor was a related party, so the definition of the related party is wide enough that it should not be covered. It should not participate under COC. Secondly, even if there is an assignment done by a related party financial creditor, and if the assignment is done to an unrelated financial creditor, that also should not be considered as non-related party, unrelated party. So they also should not participate into the COC. Now, the other concept is the connected person under section 29A. There the view is presently lenient, and we also discussed how when the Anil Ambani is having a lot of defaults, many accounts of Anil Ambani are NPA and defaulting. The various bank guarantees of Anil Ambani, like the clause C of section 29A and clause H of section 29A, which are exempted to MSME, but it is applicable to all companies of most companies of Anil Ambani. But still, the brother of Anil Ambani, that is Mukesh Ambani, has been able to take over the companies. So therefore, the Supreme Court has said that even if they are brothers, if they are not doing business together, they are not connected person. So based on this interpretation of Honorable Supreme Court, I believe Mukesh Ambani is able to somehow take over the companies of Anil Ambani. So we have done the part 1 on last Sunday, and today we are doing part 2. So I'll just share my screen, and I'll share my screen with you. It will be I hope it is visible, Ankit. Is it visible, Ankit?
Yes, it is visible.
So we actually have done a lot of slides we have already done. And we started with the relevant provisions under IBC. This we completed. Related parties and committee of creditors also we completed. And the avoidance transaction part, avoidance transactions and related parties, look back period. This is something that we actually have to do it today. So this definition we discussed, discussed about the personal definition, relatives also we discussed. The related party and committee of creditors we could discuss completely, and reasons to exclude related parties, status related parties to this Phoenix ARC judgment versus Spade Financial Services. This was also discussed, an honorable Supreme Court judgment. Then this entire judgment, in fact, was discussed at length, whereas the what is a related party and assignment of debt also was discussed. Edelweiss and versus Synergy Dore, and then this for Fortune Pharma Private Limited, that was also discussed. Pankaj Yadav. So these are all kind of related party, which was basically done. Now we have to start. So we have to start, and we have to start with the related party transactions under IBC concept and evaluation. So this is primarily the related party transactions are transactions between two parties having a pre-existing relationship with each other. The concept of related party transactions, the transactions entered into by a corporate entity with its related parties, and the treatment of such transactions is a keenly regulated aspect of corporate governance. Their relevance gains more importance in the context of avoidance transactions of a corporate entity that is facing an imminent threat or likelihood of insolvency proceedings. Avoidance transactions can be undertaken with related or unrelated parties. It is interesting to note that significant number of cases before court tribunals for determination of avoidance transactions are related party transactions. For determining whether an alleged transaction entered into by a corporate debtor with its related party was conducted in an ordinary course of business of the corporate debtor, the Supreme Court analyzed the unique nature of the relationship between the corporate debtor and its related party. The code provides for avoidance of few transactions in order to protect the creditors. As per Rule 35 capital A of CIF regulations, the resolution professional is entrusted with the duty to review the transactions of the CD during look-back period to identify avoidance transactions. Now, the concept that we are trying to explain is something like Section 43, Section 45, Section 49. And these three sections, and where the, and also probably the, these three sections which has a concept of transactions with related parties. When we say related parties, the look back period for related parties is higher. It is 2 years. With the look back period for unrelated parties is not 2 years, it is 1 year. But then the only one assumption which has been given, unless the transaction has been done in an ordinary course of business. So this is the one assumption which is available in Section 43, 45, and 49 regarding the assumption. Like, so these are the transactions which actually would not be considered as avoidance transaction in case the transaction is done in ordinary course of business. So this part we are going to discuss today, and this is avoidance transactions and related parties. See, these are the concepts that actually has been explained in various judicial pronouncements regarding related party transactions. We have captured all these kind of concept. So what I'm trying to explain now is the concept. Even in the last slide was the concepts which are explained by judicial pronouncements, or even in the preamble of the regulations or the code. Now, one of the duties of the RP liquidator is to examine and identify if the transactions have been undertaken by the corporate debtor, which qualifies as preferential transactions, undervalued transactions, extortionate transactions, or transaction with the intent of defrauding creditors. This is the primary duty. So if the RP liquidator is of the opinion that the avoidance transactions have occurred, then he is obliged to report the same to the adjudicating authority. Now, if the transactions are adjudged to be avoidance transaction, then adjudicating authority may, like, there are possibilities of various kind of remedies, and one such remedy is the issue necessary directions for reversing such transaction or directing the beneficiaries of such transaction to return any property or the beneficial interest back to the corporate debtor. So look back period we've already discussed, because the related party look back period and unrelated party look back period is different. The UNCITRAL legislative guide on insolvency law also acknowledges examining transactions entered into by the corporate debtor with its related parties with greater scrutiny. In fact, I also said in the last webinar, last episode, that in the case of individual bankruptcy, where the transactions would be identified by the bankruptcy trustee. So in that case, any transaction entered between the related parties, that has to go for the test of judiciary. So no audit is required. The RP is under obligation that if the transaction is entered with the related party, the RP will report that transaction to adjudicating authority, and adjudicating authority will take the cognizance of that. So legislative guide as released by UNCITRAL also recommends longer look-back period for transactions entered into with related parties, vis-a-vis identifying the addressing of the avoidance transactions. The scheme of IBC also says that the avoidance transactions specified time period of look back, and that is from the date of commencement of CIRP. It is a general consensus, like right from the beginning, it has been a general consensus that the look back period should be higher for the transactions with the related parties. So therefore, the entire concept of a related party, in fact, is flowing from the Bankruptcy Law Reforms Committee, and which in fact said that there should be a stricter scrutiny for transactions of fraudulent preference or transfer to related parties, for which the look back period should be specified in regulations to be longer. Now, the determination of whether a transaction is an avoidable transaction is a mixed question of facts of law, and the transaction is required to be examined by the adjudicating authority. When we look at the preferential transactions under section 43 of IBC, the look back period is 24 months for related parties, and the same is, and for other parties it is 12. It is for the other parties it is 12 months. Now the preferential transaction actually, which has been defined in such a manner that where an insolvent debtor makes a transfer to or for the benefit of a creditor, so that such beneficiary would receive more than what it would have otherwise received through the distribution of bankruptcy estate. So this is what is called a preference, that by way of a transaction, by way of any move, the priority has changed, or payment has been given, or any security interest has been created within the look back period, which was not earlier there. So the use of the preference here is to denote the act of paying or securing to one or more of his creditors by an insolvent debtor the whole or part of their claim to the exclusion of the rest. Paying or securing. So that's what I said, either payment or changing the priority, making a person who is unsecured from unsecured to secured. Number two, making payment. Number three, securing, creating a mortgage during look back period to one or more of his creditors by an insolvent debtor, the whole or part of their claim to the exclusion of the rest. This is the concept of preferential transaction. So in India, the legal position pertaining to the identification and avoidance of preferential transaction or IBC are set out in section 43-44. I think this section 43 that now all our readers must be knowing, and I've also been explaining what exactly section 43 is regarding the preferential transaction. There are three conditions: that there should be a transfer of property or an interest, and then the second is the said transfer should have an effect of putting such creditor or surety or a grantor in a beneficial position, and then it should not be exempted. So what is the exemption? The transaction is not made in the ordinary course of business, and the security interest created, that should be created for a new value. Now, in this case, it is important that we discuss the Supreme Court order in the case of Anuj Jain, IRP, for JP Infratech Limited versus Axis Bank. Now, in this case, in fact, Supreme Court held in, like it is an old judgment, 2019, the Supreme Court, in fact, laid out certain procedures and for handling the or identifying the preferential transactions, So, first of all, Supreme Court distinguished Section 43 of the IBC from Section 328 and 329 of the Companies Act, and observed that if the ingredients of Section 43 of IBC are satisfied, then the transaction is deemed to be a preferential transaction, notwithstanding the intent of the parties. Now, the bare text of Section 43, subsection 3, clause A of IBC stipulates that a transaction is exempt from being treated as a preferential transaction if it was carried out in an ordinary course of business or financial affairs of the corporate debtor or the transferee. So it's an ordinary course of business or ordinary course of financial affairs or the ordinary course of the financial affairs or the business of the transferee. So how Supreme Court observed that the purposive interpretation of Section 43 demands that the phrase corporate debtor or transferee should be interpreted as corporate debtor and transferee. So in other words, Supreme Court observed that for a transaction not to be considered as preferential transaction, such transaction is required to have been undertaken in the ordinary course of business or ordinary course of financial affair, not only of the transferee, but also of the corporate debtor. Now, that's what I said. See, when we are talking about the preferential transaction, there is a concept of related parties. Secondly, the concept of related parties is, again, there is an assumption that the transaction should not be in the ordinary course of business. Transaction should not be in the ordinary course of financial affairs. And that too, for the transferee and for the transferor. So as I said, in Section 43, there are two conditions. One, that there must be a transfer of property. And the property can be anything. Property can be any kind of assignment. Property can be any kind of payment. Property can be any kind of security creation. So that is a mandatory condition of Section 43. And then is the look-back period. It should be in the look-back period, depending upon the related party or unrelated party. And then third position is that the transaction should not have happened in ordinary course of business, in ordinary course of financial affairs, and that is not only restricted to transferee, it can be even transferee also. So this is the basic conditions of Section 43, and the judgment further say many things. But Ankit, for the time being, is there anything which is coming in your mind regarding the related party vis-a-vis the ordinary, vis-a-vis the avoidance transactions? Would you like to add anything in this part?
No, I make clear that when it is a transaction with related party, what changes also, like what we have also witnessed that in many cases insolvency courts, the 2-year period does not allow any does not have too many transactions be part of preferential, undervalued, or extortionate transactions, because that's where you have this period. And therefore, the majority of the transactions that we are able to say corridors or as transaction auditors is only under the fraud mechanism, where you say that okay, there has been a diversion of funds or there has been some kind of an activity which has resulted in fraudulent activity, and that's where you allege that. And the moment you say that, then the intent comes into place, and also the idea comes into place that if some kind of money has been spent or preferential payment or an undervalue, then it doesn't squarely fall in those sections, but rather into fraud section, 96 section.
So I think the Supreme Court continues to further analyze these phrases of ordinary course of business, ordinary course of financial affairs, and Supreme Court even tried to seek help from the ju- uh, the the judgments passed in other jurisdictions, like this judgment, which is Downs Distributing Company Pty Limited versus Associated Blue Star Stores Pty Limited, and this was a judgment given by High Court of Australia in the matter of this Downs Distributing. So it has been held that the ordinary course of business means that the transaction must fall into place as part of the undistinguished common flow of business done, that it should form part of ordinary course of business as carried on, calling for no remarks and arising out of no special or particular situation. However, it is relevant to note that the Supreme Court did not interpret the meaning of the phrase financial affairs for the purpose of Section 43. Even I am also confused what is the meaning of the ordinary course of financial affairs when we talk about identifying preferential transactions. So I can understand the ordinary course of business, but ordinary course of financial affairs, it may be slightly a different interpretation, which I'm not really sure. But then the Supreme Court has also not given that interpretation. Now, we'll see in case the the ordinary course of business or ordinary course of financial affairs. Yes, there can be some situation where the courts have given an order and the transaction has not been done at the free will of the management. So therefore, that can be because that's a financial affair, a court order or a statutory requirement. That's a common ordinary course of financial affairs. If the court places an order that you need to refund this money, that actually will be considered ordinary course of not the business or the ordinary course of financial affairs. I think this is the difference between ordinary course of business and ordinary course of financial affairs. Now, the court further analyzes that for determining whether an alleged transaction entered into by corporate debtor with its related party was conducted in an ordinary course of business of this corporate debtor, the Supreme Court analyzed the unique nature of the relationship between the corporate debtor and the related party. For example, the Supreme Court internally observed that the corporate debtor, being a special purpose vehicle, mortgaging its assets to secure the borrowing of its parent company, cannot be constituted to be in ordinary course of business of such corporate debtor. So this was actually very clear that the mortgaging the assets to secure borrowing of its parent company cannot be constituted as an ordinary business. Reason being that the two companies are independent. Parent company is independent, regulated separately. Similarly, the subsidiary company is also independent, subject to regulations. So none of these companies can say that this is an exemption which is available to kind of companies like holding companies or associate companies or subsidiary companies. So like as I said, that 1 year and 2 years, that's a difference between the related parties and unrelated parties. And given the unique influential position of a related party to undertake a preferential transaction, even at the initial stages of the IBC development, it was considered that a longer look-back period for transactions entered into with the related parties is necessary for avoiding preferential transactions, as a number of transactions diminishing creditors' wealth enter into the related parties occur not only in the zone of insolvency, but as soon as the early signals of the trouble are viable. So these are the observations of the Honorable Supreme Court in the case of Anuj Jain. Then comes the undervalued transactions. Undervalued transactions are under Section 45, and it is with the intent of keeping assets of the corporate debtor beyond the reach of any person who is entitled to make a claim against the corporate debtor, or in order to adversely affect the interest of such person is treated differently. Now, these transactions may be entered into by the corporate debtor either with a malefied intention or causing wrongful gain to its related parties, all the expenses of the all at the expense of other share stakeholders, or alternatively, in a situation wherein the corporate debtor who is in need of cash may sell assets quickly at a price significantly below the real value in order to achieve a quick result, without our having any intention to defeat or delay creditors. There are few primary conditions for undervalued transactions. One is that under Section 45, this is a primary condition that the corporate debtor or the insolvent makes a gift to a person, then enters into a transaction with a person which involves the transfer of one or more assets by the corporate debtor for a consideration, the value of which is significantly less than the value of the consideration. Such transactions have not been placed. So again, making a gift or selling an item, selling an asset, and that asset could be even receivables which can be assigned, that it can be any property of the company which is transferred. And the only exemption is that the transaction should not happen in the ordinary course of business, which we discussed in the judgment of Anuj Jain also. Now, again, JP Infratech case, in the case of IDBI Bank, NCLT Allahabad bench, in fact, has held something like the Honorable NCLT has held in the matter of that a transaction can be said to be an undervalued if the consideration for entering into the transaction was significantly lower than what it would have otherwise been had it been entered at an arm's length price. It is relevant to note that, like in preferential transaction, a transaction is exempted from being treated. A transaction is exempted from being treated as an undervalued transaction if such transaction was carried out in the ordinary course of business of the corporate debtor. So if the adjudicating authority judges that a transaction is an undervalued transaction, then it may pass an order directing the following: restoring the position as it existed, requiring the IBC to initiate the disciplinary proceeding because the liquidator or the RP, as the case may be. So the scenario that we are going to discuss is that the undervalued transactions, the assumption is the transaction should not be in the ordinary course of business, and there must be a transfer of property. So these kind of orders can be obtained. So 1 year, 2 year parties, that moratorium period that we already understand. See, the rationale for longer look-back period for related parties that the management of the corporate debtor, which has better knowledge of the corporate debtors' financial affair, may enter into transactions with the related parties to strip the corporate debtor of value upon receiving early signals of the financial. In extortionate credit transactions, there is no concept of related parties. So this is not to be covered here. Then coming to the fraudulent trading. Fraudulent trading, the concept of related party is very well applicable. In this case, any transaction can be termed as wrongful trading or fraudulent trading if during the CIRP or liquidation process, it is found that any business of the corporate debtor has been carried out with the intent of defraud creditors or for fraudulent purposes. So in case if the adjudicating authority judges a transaction to be wrongful trading, fraudulent trading, then it may pass an order that any person who were knowingly parties to the carrying on of the business in such manner shall be liable to make such contribution to the assets of the corporate debtor as it may deem fit. This case like IDBI Bank versus JP Infratech Limited, it has been held by the honorable bench as to whether the transaction can be considered as fraudulent trading or wrongful trading depends on the fact and circumstances of the case. So the look back period as far as this part is concerned, the section 66, there is no look back period for identifying transaction which could be considered wrongful trading or wrongful fraudulent trading. However, given that the nature of the transaction, it typically only persons in the management of the corporation who could orchestrate a transaction to defraud the creditors. Now, for wrongful trading or fraudulent trading, the transaction must have taken place within the meaning of section 66, and it may direct the director or partner of the corporate debtor who qualify as related parties of the such corporate debtor shall be liable to make such contribution to the assets of the corporate debtor as it may deem fit. So before the insolvency, such directed partner knew or ought to have known that there was no reasonable prospects of voiding. Yeah, see, like the analysis of various judgments is that before the insolvency commencement date, if any director or partner, if they know that there has been no reasonable prospect for avoiding, they have to, their insolvency will start and the business will be taken over by RP. Then at that time, second thing that actually has to be done, that the such director or partner did not exercise due diligence in minimizing the potential loss to the creditor of the corporate debtor. Now, these are the conditions. One, that they must know that the company is going to become insolvent or the banks will take over the assets. Therefore, either under SARFAESI Act or under IBC, therefore this is the first condition, that the red signal must have started shown that the company will be taken over by the SARFAESI under SARFAESI or IBC. And in the meantime, the director or partner did not exercise due diligence in minimizing the operational loss. The adjudicating authority in such cases, when they held a transaction as fraudulent transaction, then they can do many actions. And one action is that they can say that the liability of any person found guilty of committing wrongful trading or is to be a charge on any debt or obligation from the corporate debtor to him, or on any mortgage or charge. So this is the wrongful transaction in case the adjudicating the authority adjusts that or held that, so that actually can be reversed. Additionally, if the adjudicating authority has passed an order in relation to a person who is a creditor of the corporate debtor, it may direct that the whole or any part of the debt owned by the corporate debtor to that person, and any interest thereon shall rank in the order of priority of payment under section 53 of the Act. We have to see, Ankit, now the discussions that we have so far done is the discussion on undervalued transaction, preferential transaction, extortionate transaction, and the fraudulent trading or wrongful trading transactions. And we are trying to find out the concept of related party. So in concept of avoidance transaction, the concept of related party is one, that the look period is higher in the case of look back period is higher in the case of related parties. Secondly, the secondly the once the look back period is higher, and then the other parties, that if a transaction is with the related party, and normally it should get reported by the auditor, and the adjudicating authority shall adjudicate this. But the one concept is the ordinary course of business, which is a kind of some remedy available in case any transaction has been entered uh, as a normal business or as a common business transaction, then it would be exempted from the uh, all these actions under IBC. So then is the issue of our uh, kind of the look back period we've discussed, the ordinary course of business we've discussed, the ordinary course of financial affairs that we have discussed. Related party look back period is bigger, unrelated party smaller. So these are the various issues that we actually have to look into the related party transactions under avoidance transactions. So now I think before this, I would like to have your input, Ankit.
Yeah, so I believe, as I said before, the effectiveness of these provisions is still limited. So yes, that's the big concern, because in majority of the cases, all these transactions are very old, and rather there has already been some kind of planning. So catching the entities, or rather starting insolvency when the whole process, the company is not at that stage, is more important.
Moving forward, we have some judgments on the priority of related party claims. JR Agro Industries Private Limited versus Swadist Oils Private Limited. Again, adjudicating authority judgment, NCLT Allahabad, old judgment. And in this case, the related party was obtaining approximately 62% of the total, while the operational creditors were receiving almost nothing. So what exactly is this case? That the 62% of its dues, 62% of its dues were being paid to related parties. The operational creditors were not receiving any amount. So this was the basic transaction. In such circumstances, it was beyond imagination that after approval of the plan, the operational creditors will be willing to continue their supplies to the copy debtor to keep it as a going concern. Thus, it is important to reflect upon insolvency law of other jurisdiction wherein the priority is given to secured creditors over unsecured creditors. But there is no distinction between financial and operational creditors. This is, but then we have this case, so we are. Now, in this case, the argument was while the resolution plan was being presented by RP, the argument of RP was that the approval of resolution plan by adjudicating authority is mere a formality, because the COC has already approved the plan with requisite voting percentage, in fact, with 100% voting rights. Now, the RP is trying to say that, so what, that the related parties are getting 62% and the operational creditors are getting 0. So what? Because that's what the law says. But it was the kind of related party getting their share. So two things that I want to tell you here, like in case of liquidation, if there is a related party and related party is having some kind of security interest, or alternatively the funds are available, then the related party creditors are fully entitled to get disbursement as per section 53. So that's what I wanted to say. So this is what is the concept here that we are trying to explain. The priority of related party claims. They have a claim and they have taken their unsecured creditors, and then they have taken 62%. They are not offering anything to operational creditors because the committee, it's not a question of committee, it's a question of independent COC has approved it, because the related party would not be participating into the COC meeting because of related party. Now, in this case, the further argument of the RP was the resolution plan satisfied all the requirements of Section 30 of the code and the regulations thereunder. It was clarified that the related party was not allowed to attend and participate in the COC meeting. Hence, there was no occasion to influence the decision of the COC member. Yet, the resolution plan pays almost nil dues to operational creditors and instead prioritizes the claim of related party unsecured financial creditor according to the waterfall mechanism. Now, Section 53(1)(d) treats all unsecured financial creditors at par so far as priority of their payment is concerned and does not discriminate between unrelated creditors and related parties. And accordingly, it was emphasized that the express legal provisions cannot be bypassed even on the ground of equity. So what is the equity? The equity is that the unrelated parties are not getting anything, but the related parties are getting almost 62% of their claim. Then is the Regulation 38, Sub-Regulation 1, Clause B of the liquidation value due to operational creditor should be paid in priority to any financial creditor and in any event before the expiry of 30 days after the approval of the resolution plan. In most cases, here too, the liquidation value of the operational creditors after meeting the claims of the financial creditor was computed to be nil. Any payment to be made to such operational creditor which was over and above such value ought to be considered to be a bonanza for them. So these are some of the observations. Like, let us go to the held part. The bench examined that it may change or rearrange the priority of claim to prevent a creditor who has committed fraud, illegality, or has acted inappropriately to gain advantage over other creditors from benefiting in any manner. Considering subordination to be pertinent to fair distribution, the NCLT ordered that the related party claim should be treated in the category of equity shareholders. Thus, categorizing is under Section 53(1)(h) of the code below the rank of the unsecured financial creditors and as well as other debts of the. So this was the final held portion in the case of the JR Agro Industries Private Limited versus Swadhisht Oil Private Limited. So in this case, finally, it was held that the related parties, even if they have higher share in the claim, their claims are verified, they are entitled to money, company has money, but still the NCLT says that whatever you are giving to related party, that can be treated as equity shareholders, and equity shareholders has much lower preference. Anything, Ankit, that you would like to add?
No, I think it's all good.
The next is the Jayanta Banerjee versus Shashi Agarwal, liquidator of InCab Industries Limited. This is our own case, and where the earlier liquidator, Shashi Agarwal, he was removed and a new insolvency professional was appointed. So the new insolvency professional is the partner of AAA Insolvency. And in this particular case, the Kamala Mills Limited and Fasqua Investment Private Limited, they in fact, they were made part of the COC member as related parties, but they were taking the voting. So this was the issue basically, which was in fact one of the workers, Jayanta Banerjee, took the RP to the liquidator, earlier liquidator, that this is incorrect. So therefore, the Honorable Supreme Court order of Phoenix ARC Private Limited was also applied, and it was argued before that the Supreme Court has laid down the law that the term related party in the custody is to ensure that those entities which are related to corporate debtor can be identified clearly, since their presence can often negatively affect the insolvency process. Thus, Kamla Mills and Fusco Investment Private Limited, they are related parties to the corporate debtor inquiry in terms of Section 524F of the Code and terms. They are not entitled to represent and meet or vote in the meeting. Now, NCLAT in this case, the case of Jayant Banerjee, in the case of InCab Industries Limited, the NCLAT has held on various issues. One, Ankit, would you be able to read through these held portion of this judgment, Jayant Banerjee judgment, which is our own judgment, and held portion is one slide. I think in case you can.
Yeah, I'm going through it.
Yeah.
So the constitution of the COC violates the proviso to section 21(2) of the code, read with 12(3) of CRP regulations. Therefore, the constitution of creditors committee is a nullity in the eye of law that vitiates the entire CRP. Liquidation is like a death knell for corporate entity, corporate person. Liquidation passed on resolution of the COC, which consists of rigid party financial creditors having 77.2% voting share, is a matter of grave concern. So Honorable Supreme Court in the case of Phoenix ARC has described the entering of such related party financial creditors in the COC as an act of commercial contrivances through which these entities sought to enter the COC, which could affect the other independent financial creditors. An order for liquidation of corporate debtor passed on the sole discretion of related parties financial creditors could be fatal for the existence of corporate debtor, cannot be sustained. So it is also pertinent to mention that when the constitution of the COC itself is found to be tainted, then the decision of that COC cannot be validated on the pretext of exercise of commercial wisdom.
So in this case, Ankit,
finally in this case the liquidation order was cancelled, and then the CRP was reinitiated, and I think today we see a successful resolution for the company.
Yes, today we have resolved the company, and with more than 500 crore resolution plan is now pending before the adjudicating authority. The adjudicating authorities, I think that's what was the objective of the that was the objective of the law. So going forward on the judicial pronouncements, Ankit, you can also go through a couple of judicial pronouncements quickly. This is like Radha Industries, you understand it, and so you can start it.
So this is Radha Industries Private Limited versus Ms. Jayanti S. Iyer IRP of Bhadreshwar Vidyut Private Limited. It's a Chennai bench judgment, and the issue here was whether an assignment of related party debt, the assignee becomes related party. So it was held that the assigner, if was a related party of the corporate debtor, then by operation of law and virtue of sections 524A, the assignee itself becomes related party of the corporate debtor. If it is the transaction which always be considered as related party transactions and not the entity. So in case the right to the related party is transferred, then that transaction, whoever purchases it would understand that his rights would also be considered related party. Telangana State Trade Promotion Corporation versus AP Gems and Jewelry Park Private Limited, again in NCLAT judgment of 2021. Issue involved was whether an authority to appoint nominee director in the power of affirmative vote makes the party a related party. So many contracts can happen where some kind of an investor has put in a nominee director or some other way.
This is very important. This is an NCLAT judgment.
So it's not only So it was held that the appellant company has a control in regard to arrangement of board of directors of the first respondent company, and on this score also the appellant comes with the purview of related party as per clause L of section 24 of 5 of the code. as opinioned by this tribunal, the appellant is a related party, and the view arrived at by resolution professional to include the appellant TSTPCL as member of the committee of creditors is clearly unsustainable in the eye of law. This tribunal concurs with view arrived at by the adjudicating authority in the impugned order that the appellant is a related party. Further, the direction issued by AA in the impugned order that the resolution professional shall constitute the committee of creditors, treating the appellant as related parties free from legal errors. Viewing in that perspective, the instant appeal fails. So in this case, it was held that the related party basically is basically the related party is considered to be based on the judgment. Sai Peace and
This one is also our case. Our partner Anil Khicha, based out of Chennai, was RP in this case, and ASK Investment Managers Private Limited. They in fact have funded this company. It was a real estate company, Ambojini Developers Private Limited. So this High Peace and Prosperity Apartments, this is a home buyers association. Now, they in fact argued that the ASK Investment Manager Private Limited, they are related parties because the ASK Investment Managers, when they funded, they have in fact executed such kind of agreements that based on those agreements, it was also considered that they are part of the management. Now, what kind of clauses were there in the agreement? That they have a right to appoint director. Also, they have a right to appoint auditor. Also, they will have an escrow account to monitor the fund flow. So based on these orders, based on these clauses, it was held that the ASK Investment Manager Private Limited was related party. And once they are adjudged as related party, so it was basically the resolution plan, whatever was approved, that actually went back for the consideration of committee of creditors without ASK. Now, this is the held portion. Ankit, I just gave the background. You can just present it before the viewers.
So in this matter, an investment management company was taking part in management of the corporate debtor on the basis of an investor agreement and in the capacity of an investor. In order to determine whether a party is a related party in terms of section 524 and section 21, it is imperative to know the nature of the transactions entered into between the said party and the corporate debtor and examine the influence and interrelationship between the parties. The respondent has all the trappings of being a related party of the corporate debtor on account of the various provisions of the SHA, which gives its nominee directors on board a participatory role in the corporate debtors policies. Even though it was a financial institution, the NCLAT rightly held that protection from exclusion from COC can only be given to pure play financial institutions who convert their debt into equity. Even if the investor is controlling the board and affirming decisions in the interest of the participating investors, it still falls within the category of a related party and hence has to be excluded from the COC. So basically, even though the entity ASK management is an intermediary which basically is involved in getting money invested for investors into all these companies to debt instruments, this perhaps was a control mechanism so that they can also oversee or rather control activities in the board with respect to the company. But now, with respect to the provisions of the Act, the court found that they are related parties. Even so, the investor tag or the investor representative tag did not help them in the court.
So this is all, Ankit, in case we have to summarize this. So we have discussed related parties in view of their participation in the COC. That concept we have seen. Then we have seen the related parties under section 29A, which is the connected persons. And we have also seen the related party concept under the avoidance transactions, like preferential transactions, undervalued transactions. And in extortionate transactions, we don't think there is any related party concept. Then we've seen under section 66, the fraudulent transactions that we have concept.
So
This
one
was
thing,
all. Yes.
so one thing which is important to mention here is that we also see a change that almost all investments that happened on in startups or by investors in the past were through the CCPS route, compulsory convertible preference shares. But lately, the use of optionally convertible debentures is also increasing strength. And I think part of that is because of these judgments that we discussed, where a CCPS would be considered as an investor, whereas a OCD can be considered as a debt in case the money is not available for equity holders.
Fair enough, Ankit. I think this is the we can conclude our subject as a related party, and I still feel that now I believe we are preparing now something called all kinds of rules, starting from NCLT rules, and then the rules made under IBC. So we are preparing a detailed analysis of rules and the how the NCLT functions, all rules for NCLT, and then we will also do something like NCLAT rules. So that will be our next subject. And
We can also take up the discussion paper for valuers. That is also an important development that has happened, although that is a draft paper, but then it can still be used to enhance the valuation process that many insolvency professionals are following.
in fact, like I met some officials of IBI, and they are saying that now this, uh, I think they are now prevailing upon various other uh, laws, various other ministries, where they actually will kind of notify that the valuation means the valuation by registered valuers.
Yeah,
In
so
other,
within the ministry, it has already been decided on 25th September. That is what was announced on Valuers Day. So that change is forthcoming. Let's see when that happens practically. But then yes, with respect to IBC and valuation, that is also changing. It's a very extensive document. I've already gone through it, and I think it calls for a discussion.
I think maybe that we next subject we can take up this only.
Yeah, we can take the valuation and
Yeah,
the valuation guidance.
right, right. Thank you very much for participating and wishing you happy Diwali and enjoy the festivities of India. Thank you very much. Thank you.
Thank you, everyone. Thank you so much.